Welcome back to Clear Probate, where we make Florida probate and estate planning easy to understand. If you've been named as an executor, or in Florida terms, a personal representative, one of the first questions you'll face is, what documents do I actually need for probate and where do I file them? The truth is, probate is a document-driven process. Courts don't move forward until the right forms are filed in the right place at the right time. Missing a document or filing it late can slow the estate down or even create legal problems for the personal representative. In this video, we'll walk step by step through why probate documents matter, the key documents required to open probate, documents you'll file during the process, final documents needed to close the estate, common questions families ask, and practical tips to keep you on track. By the end, you'll have a clear checklist of what's required and where to file it. Probate is the court-supervised process of settling someone's estate. That means the court doesn't just take your word for it. You need to prove what assets exist, who the heirs are, and that debts have been handled correctly. Documents are the way the court monitors the process. They create an official record that the right person is acting as personal representative. Creditors are given notice. Assets are inventoried and valued. Beneficiaries receive their rightful distributions. Without these documents, the probate process simply cannot move forward. Let's begin with the very first stage, opening probate. When someone dies in Florida, probate is usually started by filing a petition in the probate court of the county where the deceased lived. Here are the core documents you'll need to open the case. Petition for administration. This is the formal request to open probate and appoint a personal representative. It includes basic details about the deceased, the estate, and the person seeking appointment. Filed with the probate division of the county circuit court. Death certificate. An official copy of the death certificate must be attached, usually obtained from the county health department or vital statistics office. Last will and testament if one exists. The original will must be filed with the court within 10 days of death, even before the petition is filed. This document shows the deceased's wishes for asset distribution and who should serve as personal representative. Oath of personal representative. A sworn statement by the proposed personal representative promising to faithfully perform their duties. Designation of resident agent. Florida requires personal representatives to designate a Florida resident as their agent for service of legal papers. Proposed order for appointment. A draft order for the judge to sign, officially appointing the personal representative. Once these documents are filed, the court will review them. If everything is in order, the judge issues letters of administration. Letters are the official document giving the personal representative authority to act on behalf of the estate. Once probate is open, the paperwork continues. These documents ensure the estate is being managed correctly. Notice to creditors, filed within 30 days of appointment, must be published in a local newspaper and mailed to known creditors. Inventory of the estate. A detailed list of all probate assets and their value at the time of death must be filed within 60 days of receiving letters of administration, affidavits and notices. For example, proof of publication for the notice to creditors, or notices of administration served to beneficiaries. Creditor claim responses. If creditors file claims, the personal representative must respond. This may include paying valid claims, objecting to others, or filing motions with the court. Accountings. Interim accountings may be required for longer estates. These show income, expenses, and distributions during the probate process. All of these documents are filed with the same county probate court handling the estate. When debts are settled and assets distributed, the estate is ready to close, but it won't close automatically. Final documents are required. Petition for discharge. Filed by the personal representative asking the court to discharge them from duty and close the estate. Final accounting. A detailed report of all transactions during the probate process. Income, expenses, creditor payments, and distributions to beneficiaries. Receipts from beneficiaries. Signed receipts showing beneficiaries received their distributions. These are filed to prove the assets were delivered correctly. Order of discharge. Prepared for the judge's signature. Once signed, the estate is officially closed and the personal representative is released from further duties. Without these closing documents, the probate case remains open and the personal representative may still be liable. Common questions families ask. Where do I file probate documents? All probate documents are filed with the circuit court in the county where the deceased lived. Within the court, the probate division handles these cases. Do I need original documents or copies? The original will and certified death certificate must be filed. Other documents, like petitions and inventories, are usually filed as signed originals but can be printed copies of templates prepared by attorneys. Can probate documents be filed electronically? Yes, Florida courts use an electronic filing system, and attorneys must file documents this way. Individuals representing themselves may file paper documents directly with the clerk. What happens if I miss a filing deadline? The court may issue an order requiring you to file, impose fines, or in serious cases, remove the personal representative. Staying on top of deadlines is critical. Do beneficiaries get copies of all documents? Beneficiaries are entitled to notice of major filings, including the petition, inventory, and accounting. This ensures transparency. Practical tips for executors and heirs. Create a timeline. As soon as you're appointed, mark key deadlines. 10 days to file the will, 30 days to file the notice to creditors, 60 days to file the inventory, and so on. Stay organized. Keep a binder or digital folder with copies of every filed document, notices from the court, and correspondence with creditors. Work with professionals. Many probate documents are technical. Having an attorney prepare or review them helps avoid costly errors. Communicate with beneficiaries. Let them know when documents are filed and what they mean. This reduces confusion and builds trust. Double-check before filing. Incomplete or inaccurate documents can be rejected, delaying the process. Review carefully before submission. Let's take the example of Robert, who was appointed as personal representative for his aunt's estate in Fort Lauderdale. He didn't realize he had to file the original will with the court within 10 days of her death. By the time he filed it, weeks had passed. The judge questioned the delay, which complicated the early proceedings. Once he got back on track, Robert worked with an attorney to file the petition for administration, the death certificate, and the inventory. He also filed creditor notices and later submitted a final accounting with beneficiary receipts. Because he carefully documented everything after the rocky start, the judge ultimately approved the petition for discharge, and the estate was closed smoothly. Robert's experience shows that while probate paperwork can feel overwhelming, staying organized and filing on time keeps the process moving forward. Now you know the key documents required in Florida probate, from opening the estate with the petition and death certificate to managing the estate with inventories and creditor notices, all the way to closing the estate with final accountings and receipts. Probate is a paperwork-driven process, but with the right documents and deadlines in mind, it doesn't have to be overwhelming. If this video helped you, subscribe to Clear Probate and let us know your thoughts in the comments. We read everyone. Here's a question for you. Which probate document do you think is the most confusing? The petition, the inventory, or the final accounting? Share your thoughts below, and we may cover your question in a future video.
If this helped bring clarity to your situation, hit that like button and subscribe for more guidance.